If you think accepting a bully offer always leads to a smooth sale, think again. These sellers accepted a bully offer that only materialized because of their agent's alleged misrepresentation of multiple offers. They all got sued. Hi, I'm Viviana with the Live Realty Group, and I'm a licensed real estate agent in this beautiful province of Alberta. This is our team's brand new channel, Live in Alberta, here to help you with everything real estate. So if you've ever wondered what buyers and sellers get sued for in real estate transactions, I've got a video for you. I'll break down a court case and talk about what you can do to protect yourself as a consumer and what we as agents can help you with. And if you like this content, please like, share, and subscribe. Help a new channel out. Today, I bring you a case from 2022, You versus Falkovsky, where the buyers, thinking they were going into multiple offers, made a bully offer only to regret it when they found out no other offers were present and the neighbor's house sold for a lot less. You can find the details on canley.org, but I've got the highlights. So You, a realtor, and his wife agreed to purchase a property from the Vasilyevs for $222,000 over the list price of $1.688 million. This offer was influenced by the seller's agent Falkovsky, who said there were other offers on the table up to $1.9 million. So their offer of $1.91 million was accepted unconditionally, and around this time, the Canadian government announced the foreign buyer ban. So the market kind of shifted, it cooled off a little bit. The neighbor's property ended up selling for a lot less, and the buyers later found out that there were no such competing offers on the property they offered on. They felt misled into paying more than what they felt the house was worth. So they took the selling agent, the sellers, and the brokerage to court over fraudulent misrepresentation, seeking to get out of their contract to purchase, recover their $90,000 deposit, and punish the selling agent for lying to them. From the seller's perspective, the buyers hadn't yet closed on their sale, but were taking everyone to court. So they figured the buyers were breaching their contract by trying to walk away from a firm deal. The sellers already bought their next home and ended up with huge financial losses because of the failed sale on their current home. They ended up selling that property for $1.33 million. So they counterclaimed for the difference between the original sale price agreed upon by the buyers and the lower sale price at which they ultimately sold it for, less the $90,000 forfeited deposit. The seller's agent ended up off the hook for fraudulent misrepresentation because there just wasn't enough proof to establish that he deliberately made a false statement, knowing it's not true, to convince someone to act in a certain way, like entering into a contract. There just wasn't enough proof that the buyers put forward that bully offer because of what the selling agent said. And also the buyers couldn't establish that they suffered any real damages other than claiming they just would have paid less for the home if they had known there weren't any competing offers. So the judge ruled against the buyers, dismissing their claims and upholding the seller's counterclaim. The judge found no basis for rescinding the contract on the grounds of misrepresentation. There just wasn't enough concrete evidence. And also, you can't really punish someone if there are no actual damages being suffered. The buyers were held liable for breach of contract and were ordered to pay damages to the sellers for their troubles in the amount of $514,841. So $500,000, and they don't even have a house to show for it. That's rough. So what did we learn from this? First, inherent to a bully offer is the risk of overpaying to position your offer as the most attractive and win the property. If you understand this risk and you're okay with it, great. You'll likely win in a seller's market. But if you get cold feet after you found yourself in a firm sale, there are big financial and legal consequences if you back out and breach your contract, like $500,000 in a case like this. Second, know who is working on your behalf. If you're a buyer without your own agent and you're relying on the seller's agent for information or to write the contract, well, guess who the seller's agent works for? The seller, not you. They have no obligation to work in your best interest. Once you sign a buyer representation agreement with an agent, you legally have agency, which means that agent has a fiduciary duty to work in your best interest always. They can negotiate for you, they can advise you, all that kind of stuff. We'll have a video on that soon enough, why you should sign a buyer agreement. In this case, the buyer was a realtor, so there are some blurred lines here, and I have a feeling that this court case was just so that he could publicly punish the other realtor for misleading him. The Live Realty Group is here to help. Just reach out. Thanks for watching, and if you found this video helpful, don't forget to like, share, and subscribe. Ring that notification bell so you never miss a video from us. See you next time.